Yes, well, I'm not practicing anymore, but I've spoken to a lot of people who are, and I think the general consensus is yes. And there could be a number of reasons for this. Silence. So maybe there has been a bit of a pause, but probably more in the kind of the birds have all stopped singing kind of way. And it's resonant of what happened in 2008 in the financial crisis, where there was a pause of several months, not to say up to a year, before parties started to take action against each other in cases that didn't require urgent steps. I think there's a couple of reasons for this. And one is that in the middle of a very significant crisis, people tend not to litigate, or business people don't, because they're too busy stabilising the situation and keeping the ship afloat. It's only after things have calmed down, and fingers crossed we may be entering that period, that people pause and decide that they need to take some sort of legal action. And the other thing, which I think was also thrown up in the financial crisis, was that new issues come up, novel issues come up. So you really have to pause and think about how they work legally. So that happened in some very sophisticated financial products in the financial crisis. But here we have some new explorations of things like force majeure and frustration to think about. So I think there's a lot to consider before taking action. But people appear to have done some considering, and now they're starting to go to court. No, but it can be done, actually. And that's something to think about when you're going through your dispute resolution processes, that you need to find a way of maintaining the relationship. And it is difficult. And it would be a shame if relationships fell apart because of poor personal relationships. I think people have to be realistic throughout a dispute resolution, starting from the first conversations that you have about a contract. There will be issues that come up. There'll be points made about people and on the other side, on your counterparty, and what they've done in relation to the cause of the dispute, whether they've omitted to do something, they've done something that somebody didn't like. And all disputes, including those between large corporates, are in fact personal. However, I think you can maintain the relationship, but it's far easier to do that if you're sitting across a table and talking about it than you're sitting across each other in court. Well, I think it is that question of exploring each other's position. So you need to think about your own position, think about what you can concede in order to preserve your must-haves. It's very key to understand the other side's position, so you understand the stress they're under, what they can deliver, what they just can't deliver, in which case they can't deliver it, and there's nothing you can do about that. Well, I think everybody always has to think about ESG these days, and in relation to this, I think it's more of an S and a G consideration, and this would be the impact of what you do, the steps you take in relation to resolving the situation on the communities that are serving your business. This could be local communities, could be your employees, or it could be the communities of the employees of your counterparty who depend on them. So I think in that sense, that's the S, and the G is the way you run your organisation. Are you an organisation that has good governance and is a good corporate citizen?